Let us start. First of all, we read quotation. जब थक जाओ, when you get tired. जब आप थक जाओ, आराम कर लो, टेक रेस्ट, लेकिन कभी हार मत मानो। लेकिन कभी हार को स्वीकार मत करो, अनवरत कार्य करते रहो। कब तक? जब तक सफल ना हो जाओ। ये जो सूक्ति है, ये जो मैगजीम है, इंस्पायर ऑल ऑफ अस। वर्क and work continuously, constantly. Okay, yes, start. Question number first. In which of the following cases it was held that section 27 of the Evidence Act is an exception to section 24, 25 and 26? In which case it was decided 27, section 27 of Indian Evidence Act is the exception? Students, it was decided in the case Dev Man Upadhyay versus State of UP. Yes, this is the case. In this case, it was decided section 27 is the exception of section 24, 5 and 6, because any statement, if given under inducement, a confession is made under inducement, promise, etc., shall not be relevant. A confession, a statement is given before police officer, shall not be relevant, shall not be admissible. Likewise, any confession is made in the custody of police officer is not admissible. All these things are mentioned in the section 24, 5, 26 in sequence, but section 27 says that even though confession is made before police officer, any statement, if given by an accused before in front of police officer, but if the whole statement or any part of the statement is, according the whole statement or any part of the statement, if a fact is discovered by the police officer, the discovered fact shall be relevant. It means any confession or part of the confession relating to the discovered fact shall be admissible, though such confession is made before the police officer or such confession is made before police officer or in the custody of police officer, at such confession shall be relevant, shall be admissible. It is said, it is decided in the case State of UP versus Devman Upadhyay. Next question. In which case Section 27 held constitutionally valid? Yes, in the case of Devman Upadhyay, Supreme Court also interprets its constitutionality. It means a question was arisen that it was against to the Article 20 Clause 3rd, Section 20 Clause 3rd, self-incrimination. If any statement is given by an accused before magistrate relating to self-incrimination, because he say, yes, I killed and the axe was hidden so and so at that places. If any statement is given by the accused, such statement shall be relevant, shall be admissible as a confession under Section 27, though the statement was given before the police officer, because the fact was discovered according to the statement, according to the confession made before the police officer. In this case, it means Devman Upadhyay. In this case, Section 27 was declared as a valid article, as a valid section. It is not against to Article 20 Clause 3rd. The Supreme Court decided it. So the second question, answer of the second question is A. Devman Upadhyay versus State of UP. Question number 3rd. In which of the following cases constitutionally of Section 27 was challenged by violation of Article 23, yes, of the Constitution? Such challenge was arisen in the case of State of UP versus Devman Upadhyay. C option is the correct answer of the question 3rd. I have stated before. So C is the correct answer. Okay. In this case, Section 27 was challenged that it violate Article 20 Clause 3rd, self-incrimination. So it is unconstitutional. But the Supreme Court decided that Section 27 is not against to the Article 20 Clause 3rd. It does not violate Article 20 Clause 3rd. So Section 27 is constitutional. The correct answer C of the question. State of UP versus Devman Upadhyay is concerned with confession. Yes, confession. Okay. Next question. Telling his wife that P's wife had called him to receive payments due to him. K leaves his house. After 2 days, his dismembered body is found in a trunk. Dismembered, it means part of a body, part of the body was found. Any part of the body was found. In P's trial for murder of K, the statement made by K of his wife is admissible. Why? Pakla Narayan Swami, in the case of Pakla Narayan Swami versus emperor, the problem is relating to that. It means the problem is concerning to the case. This problem is relating to the concerning to the Pakla Narayan Swami case, and in that case the statement was given by the person, by the aggrieved, by the victim before his wife was an admissible confession. So here also it is also admissible. First of all, read the option. Inadmissible, wrong. Partly admissible, wrong. Inadmissible as it does not directly relates to case death. Next, admissible, not admissible as it relates to the circumstances of the transactions which resulted in case death. Yes, D is the correct answer. Admissible as it relates the statement that was given. The statement was given by P to his wife that he is going to K's house to receive money, and after some time his dismembered body was found. It means dismembered body was found. It means he was actually the statement actually relating to the circumstances. So the correct answer of the question 5 is D. Yes. Next, after committing a crime, a person in a state of intoxication accepts the crime. It is permissible and admissible under the Indian Evidence Act, Section 29. Yes. Any statement is given under Section 29, intoxication, such statement shall be admissible, relevant under Section 29. So the correct answer of the question is A. A is the correct answer. Next, a confession does not become relevant if it is under the promise of confidentiality. It is also mentioned in the section 29. Any confession if or any statement if given by the accused under promise, confidentiality, or in interrogation, such confession shall be admissible. So it under section 29. So the correct answer of the question shall be under the promise of confidentiality that is has been obtained from the accused as a result of fraud, yes, while the accused was drunk when it is done in front of a police officer. What is the question? What is the question? A confession does not become relevant. This is the question. It means when the statement or when the confession does not become relevant, if it is under the promise of confidentiality. Yes, if such statement is given before the police officer. Yes, if the statement is given before the police officer, such statement shall be irrelevant. If he does not say before the police officer, then any statement if given shall be relevant. Okay, so the correct answer of question 7 is D. What does say? A confession does not become relevant when it is done in front of a police officer. Where? Section 26. Section 26. Because if any confession is not admissible in other way, in this case under section 26, then the confession, any confession if given before, any confession if given under promise, fraud, or interrogation, all the confessions shall be irrelevant, inadmissible. But if it is admissible in other way, it means it does not come under any section of Indian Evidence Act that make it inadmissible, then only on the basis of interrogation, fraud, the confession shall not be irrelevant. It means the confession shall be relevant under section 29. So the correct answer of the question shall be D. D is the correct answer. Next question. Under Evidence Act, a statement made by co-accused, if any statement made by co-accused at the time of commission of the offense, it means co-accused made a confession. So such confession shall be admissible under section 30. Yes, section 30 says about the confession. Yeah, section 30 relates to the confession of co-accused. Confession of co-accused. Okay. Next question. Confession of one accused person is relevant against another co-accused, yes, person, under which following sections of the Indian Evidence Act. Confession of one accused person is relevant against another co-accused person, under which following sections of the Indian Evidence Act. Section 30. If co-accused makes a confession against other accused, against any other accused, such confession shall be relevant under section 30. Yes. So the correct answer of the question 9, C. C is the correct answer. Next. A and B were jointly tried for the murder of C. Murder of C. A and B were jointly tried for the murder of C during trial. Yes. A said, B and I murdered C. What is the nature of this evidence against B? What is the nature of the evidence? What is the nature? Substantive evidence. Substantive means only on the basis of such evidence the person accused can be convicted. If the evidence is substantive, only on the basis of such statement, such confession, the person accused shall be convicted. But if other evidences are also required to substantiate the conviction of the accused, it means such evidence shall be called corroborative evidence. The correct answer of the question, corroborative evidence. Okay? It means here if any confession A and B were jointly tried for the murder of C, A and B were jointly tried for the murder of C. During the trial, A said, B and I murder C. A said. The statement, the confession of A is against to whom? B. Because A says that A and I jointly murder C. It means the statement, the confession that is given by the A against co-accused under section 30, such statement, such confession shall be a corroborative evidence, not substantial. So B is the correct answer of the question. Yes. Thank you. That's all. That's all.